You speak up about something at work that crosses a line. Maybe you reported a coworker for harassment, asked HR why the women on your team get paid less than the men, or told your manager you need an accommodation for a disability. 2 weeks later, your schedule flips to the worst shift. Your manager stops including you in meetings, and your next performance review reads like it's about a completely different employee. Some people may think it's just bad luck, but what's actually happening is one of the most common and most illegal forms of workplace retaliation, and federal law gives you serious tools to fight it. Before we get into it, this is legal education and not legal advice, so check your specific situation with an employment attorney before you do anything. Retaliation has been the #1 type of complaint filed with the EEOC for 17 years running. That means retaliation cases outnumber race, sex, and disability claims combined. So when employees speak up, a huge percentage of them get punished for it. The legal protection kicks in the moment you engage in what the law calls protected activity. It covers filing an EEOC complaint or helping someone else file one, reporting discrimination or harassment to HR or to a manager, refusing to follow an order that would require you to discriminate against another person, asking about your own pay or someone else's pay in a way that could reveal wage discrimination, requesting a reasonable accommodation for a disability or a religious practice, and participating as a witness in a company investigation involving those things. Any one of those acts puts a legal shield around you from the moment you do it, and the shield applies even if your complaint turns out to be wrong. As long as you had a reasonable good faith belief that something discriminatory was actually happening, then you're covered. Most people picture workplace retaliation as getting fired, and wrongful termination is the obvious version courts see constantly. But the Supreme Court settled back in 2006 that the law reaches much further than that. In Burlington Northern versus White, the court held that any action an employer takes counts as retaliation if it would discourage a reasonable worker from making a discrimination claim. That standard opened the door to 5 specific forms of retaliation that don't look like retaliation on the surface, but are illegal if you know what to look for. The first is the sudden schedule change. You were working days, and now you're on nights, or you had weekends off, and now you're closing every Friday and opening every Sunday. The pay is technically the same, but the schedule wrecks your life. The second is isolation. You used to be invited to meetings, CC'd on project emails, and brought into work conversations. Now, you're suddenly out of the loop. Your manager goes quiet when you walk into the break room, and coworkers stop eating lunch with you. This one is hard to prove, but when it starts right after you reported something, the pattern itself becomes evidence of a hostile work environment claim. The third is micromanagement. You were trusted to do your job for years, and then overnight your manager is demanding daily check-ins, reviewing every email you send, counting your bathroom breaks, and writing up small mistakes they used to ignore. Courts have recognized this pattern as a materially adverse action when it fundamentally changes the experience of doing the job. The fourth is the false or inflated performance review. You had years of excellent reviews on file. After you complained, your review reads like you've been incompetent the entire time you've worked there. Employers do this because they think it builds a paper trail that justifies firing you later. But what it actually does is create evidence for a retaliation lawsuit, because any jury can compare the old reviews to the new ones and see exactly what happened. The fifth is reference sabotage. Maybe you've already left the company, and now every potential new employer who calls is getting a strange and negative version of your work history that doesn't match reality. This one often happens months after the employee is gone, which makes people assume it's too late to do anything about it. But post-employment retaliation is illegal under federal law, and courts have awarded damages for exactly this kind of behavior. So, where does the line actually get drawn between real workplace retaliation and a normal management decision? Employers still have the right to run their businesses, and the EEOC itself has been clear that filing a complaint doesn't give you lifetime immunity from ever being disciplined again. The way courts work through this question comes down to a three-part framework called the McDonnell-Douglas test. First, you have to show you engaged in protected activity. Second, you have to show your employer took a materially adverse action against you. Third, you have to show a connection between the two, which is where most cases get won or lost. Temporal proximity is the big one in that third element. If you filed a complaint on Monday and got written up on Friday, that timing alone can create a legal presumption of retaliation. The closer the two events sit together, the stronger the inference becomes. Once you've built a case, the burden shifts to the employer. They have to offer a legitimate, non-retaliatory reason for what they did, such as underperformance, missed deadlines, or a policy violation. At that point, the burden comes back to you to show their reason is pretext, meaning a cover story for what they were really doing. Pretext gets proven with documents, timelines, comparisons to how other employees were treated for the same conduct, and contradictions between what the employer told you out loud versus what they put in writing. This is why documentation is everything in an employment discrimination case. Keep copies of your old performance reviews at home before anything happens. Save emails that show you doing good work. And keep a dated log of every interaction with your manager and HR from the moment you engage in protected activity. Screenshot your schedule, your meeting invites, and the tone of emails before and after, so a jury can see a side-by-side comparison. The EEOC complaint process itself starts with a deadline you cannot miss. You have 180 days from the retaliatory act to file a claim, and in states that have their own fair employment agency, the window extends to 300 days. Missing that deadline is fatal to your case. You can submit the claim yourself for free through the EEOC's online website, and you don't need a lawyer to start the process, but you almost certainly want a lawyer by the time the investigation gets serious. If you think any of this is happening to you right now, do 3 things this week. Start a documentation log immediately. Check your state's filing deadline so you know how much time you actually have, and talk to an employment attorney before you confront your employer or quit. Because what you say or do can either strengthen or destroy your case before it ever reaches an investigator or a courtroom.